mlemavu sisi tumepitia mambo mingi, ndio leo hii kwa sababu mimi Jimmy Wanjigi ndiye aliandikia barua akanituma kwa Kinoti, na Kinoti alienda akajibu hiyo barua, na vile alijibu barua tulienda na Jimmy Wanjigi mpaka kwa Kinoti na tukaelezewa pahali civilian tunaweza chukua bunduki zetu, na tukaenda huko na tuka-apply, na already Jimmy Wanjigi anajua na anajua field yake, na hii evidence yangu nilipeana kotini. Jaji Mulima hakusikiza evidence yangu, akasema mlemavu hawezi pata mtu wa kumtuma. So hiyo kitu ndio imeniweka kwa akili yangu nikuja nitetea haki ya walemavu, kwa sababu hata sisi walemavu ni watu, tunaweza tumwa, tunaweza fanya kazi. So naomba koti hii, na ndio nilipea mawakili wangu hiyo nafasi wani-advise George Mulima akae kando, evidence yangu ile niko nayo isikizwe, kwa sababu hata kuna mawakili walikuwa wanaandika kwa mitandao Kinoti hafai awe kwa hiyo ofisi, anafaa awe kamiti, kwa sababu niliona kuna siasa ndani yake, na mimi nimesimama na ukweli mpaka ijulikane ukweli. Hata kama wewe ni mtoto na uko na ID na uko na idea na uko na watu ambao wanakuamini, mpaka koti itanisikiza na mpaka Mulima akae kando, evidence yangu isikizwe, kwa sababu yeye alikataa. Na nataka kuambia Wakenya ile evidence niko naye si ya uongo. Jimmy Wanjigi ako, Mulima anajua iko, mawakili tumepresent. Kwa hivyo tunaomba JSC na waomba nikiwa mnyenyekevu kama mtu ambaye anasimamia walemavu, hata sisi walemavu saa ingine tuwe tunasikizwa siku moja. Kwa hivyo namuomba Kinoti asiwe na wasiwasi, naambiwa ni kwa sababu Kinoti ni Mmeru. Yes, naweza hata tokea bila hata nguo kwa sababu ni Mmeru, kwa sababu Kinoti kazi ile anafanyia Wakenya hawafanyii kwa sababu ni Mmeru. Anafanya kazi ya haki ya ukweli kwa kila mtu. Hata mimi nikiwa na makosa Kinoti hawezi nisamea. Kwa hivyo kama court kweli walikuwa wanafuata ukweli, mbona Kinoti peke yake ndiye amefungwa? Ulifunga watu wengi, mkafunga Kinoti. Kufunga Kinoti 4 months, unafuatisha tena fuatanisha warrant of arrest again. Umeconvict mtu na unampea warrant of arrest again. Kwa hivyo kuna interest iko ndani ya hii kesi, na ndio nimeumwa nikatoa pesa zangu nikatafuta lawyer ning'ang'anie haki yangu na ya Wakenya na ya mlemavu mwingine Kenya hii. Yule mlemavu ambaye atatumwa asiogope kutusiwa wala kutishiwa na watu. Tusimame ndio walemavu tuwe sisi ndio tutainua Kenya, juu Kenya pahali inaenda unapata kama huduma namba inaanguswa na koti, na kuna yule ana evidence lakini huwezi jitokeza. Kwa hivyo walemavu tutokeni, tusimame na haki, na haki itatusaidia tuinue hata watoto wetu. Asanteni, nitaendelea na hii kesi mpaka mwisho. Wale wanatishia wanitishie, nimezoea kutishiwa. Mimi ni wrong, yule hawezi ogopa kitu.
Instructions from our clan to Makarina on behalf of over 1,500 disabled people in this country to file a petition to the Judicial Service Commission for the removal of one Judge Murima of the Constitutional Division of the High Court. Reasons being that Makarina has instructed us on the following grounds. One, but the judge has been acting in a manner contrary to the expectations of the judge. That is enough ground for removal of the judge, in the sense that one, when the judge sentenced one Judge Kinoti, he refused to get Judge Kinoti to come to court, to present himself, to defend himself, to show cause and file his mitigation. Two, on the ground that the firearms that are being the subject of discussion are military firearms that can destroy a whole of Nairobi. The firearms are more than 790 rounds of ammunition, and they are military guns, over 14 military guns that are not supposed to be the hands of citizens. The question Makarina is asking, if one Jimmy Wanjigi has that guns, how do you expect these people to run away when the bullets are coming from those guns? They are unable to run away. They use wheelchairs. They are worried about their safety, and that's why they have come to raise this issue. Third, they are saying that the judge who convicted the Director of Public Prosecution, the Attorney General, the Inspector General of Police, and the DCI. 4 of them were convicted, but only one, Judge Kinoti, was sentenced for contempt of the court. So Makarina feels that that is not the right way to deal with it. And also the last ground that Makarina puts on is that the judge brought up ulterior, exterior issues, evidence that was not there. He has managed to get the proceedings of what happened in court and the sentence or the ruling. We have attached a copy of the ruling of the judge. The ruling is completely not a true reflection of what happened in court. The proceedings in court are different from the judgment or the ruling of the judge. So we have filed a petition for the JC for the removal of the judge, and there are very many other grounds Makarina will put across that demand that the judge has failed the test. And this is a procedure provided for under the Constitution, that any party aggrieved with the conduct of a judicial officer, you file to the Judicial Service Commission. Once the Judicial Service Commission finds that the grounds are substantive, they will recommend to the President to form a tribunal under Article 168. Then the judge, if found culpable, will be removed. It's not the first time judges have been removed in this country, neither is it going to be the last time in this country. So Makarina, and on behalf of the very many vulnerable group, has filed this petition. He has annexed, for example, the law monthly report, a magazine that clearly says that upon the DCI arresting one DCJ, Justice Wilu, there is going to be a serious attack on the Director of Criminal Investigation, and the judiciary will not be sympathetic to one Judge Kinoti. And according to him, according to our client, he is convinced that is why Judge Kinoti is being punished by one Justice Murima. Those are instructions of our client. My client
returned a sentence, sentencing Mr. George Maingi Kinoti to 4 months imprisonment, having found that he had been in contempt of court orders that were issued by Justice Chacha Mwita in a petition that had been filed by Jimmy Wanjigi and his wife. Now, immediately following the passing down of the conviction and the sentence by Justice Anthony Mrima, Mr. Michael Makarina got wind of word that there has been Mr. George Kinoti has been sentenced to imprisonment. And due to some information that he had in his custody, information that had not been initially shared with the court, he approached the office of the Honorable Attorney General, and he furnished them with documents that were meant to suggest, number one, that he had been appointed as an associate or as a representative of Mr. Jimmy Wanjigi to approach Mr. George Kinoti to help in the controversy that had arisen between Mr. George Kinoti and Mr. Jimmy Wanjigi. Number two, he also had information that there was a communication that had since been written by Willis Otieno, an advocate representing Mr. Jimmy Wanjigi, to the Firearms Board, representing their knowledge, their full knowledge, that they had information that these guns were indeed in the possession of the Firearms and Licensing Board. So, on the 22nd day of November 2021, the Honorable Attorney General preferred a review application before the learned judge in the hope that the court would correct its error after it had either been misled by the representatives by Mr. Wanjigi, and moreover, because there was information that had since become available to Mr. Makarina that was not availed before the court. So ultimately, we saw that the court rejected in its totality the application that was presented before it for review. And the court affirmed its initial position that indeed it had found Mr. George Maingi Kinoti in contempt of court orders, and it was convinced that the only desirable punishment that was available for Mr. Wanjigi, for Mr. George Kinoti, was an imprisonment for 4 months. So the petition that has been filed seeking the removal of the judge is simply but an inquiry, is simply an invitation to the Judicial Service Commission to call to look at the conduct of the Honorable Judge as far as the case filed by Jimmy Wanjigi and as far and to the extent that it relates to Mr. George Maingi Kinoti is concerned. So that in the fullness of time, it is hoped that that the Judicial Service Commission shall find that indeed there was no evidence that the court acted upon or that influenced the mind of the court to arrive at the conclusion that indeed Mr. George Maingi Kinoti was in contempt of court orders in the initial place. And this should be understood from the point, as my senior Mr. Danstan Omari had mentioned, that there were 3 respondents in that case, and how the court arrives at the conclusion that it is only Mr. George Maingi Kinoti that is responsible for withholding these particular weapons is something that the client is yet to reconcile with. It is not understood up to this moment why of the 3 the judge singled out one single individual. That is on one fold. On the second, we ask ourselves that in view of the sentencing policy guidelines of 2015 that are there, and knowing very well that when it comes to punishment, there are a number of tools that the court can use to ensure that even while we are punishing people who might have run afoul of the law, that we also protect the dignity of the procedure or the process itself. And therefore, was the court well aware that there are other forms of punishment that probably are available in view of a situation such as the one that it was confronted with? And therefore, even as we acknowledge that there has been an appeal that has been preferred challenging the conviction and the sentence that was meted by the Honorable Judge Justice Anthony Mrima, there are also concerns that moving forward, is it a question of the court misconducting itself, or moving forward, is it a court that has not really understood the process or the procedure that should be used by a court when approached with an application for a contempt of court? So a question of competence, a question of conduct, that is the question that has been presented before the Judicial Service Commission to guide us and to help us understand whether the court has acted in the greatest public interest, the court has respected its oath of office as it took. I think that should be all.